All right, let's now move on to the second special issue in the closely held corporation. The first special issue was fiduciary duties in the closely held corporation. We just finished talking about that. Let's now talk about the second issue, which is the transfer of shares, the transfer of ownership interest. Before we go into the details, let's look at the basic legal framework that is governing the transfer of shares in our three different business organizations. First, in the corporation, your shares, your ownership interests are freely transferable. Those are the default rules. But a shareholder may not demand buyout at any time. So for example, if the shareholder wants to sell her shares and she can't find a third party to buy the shares, she cannot demand that the corporation or the other shareholders buy her out. In a partnership, your ownership interests are not freely transferable. You may not transfer your ownership interest to a third party unless the other partners all agree. But you as a partner, you can demand buyout of your ownership interest at any time at fair market value. This is withdrawal at will, or it's also called dissociation at will. So if I'm a partner in a partnership and I want out, I can say, I want out, buy me out. And I will force the partnership to buy me out at fair market value. This is the default rule. We can naturally change this rule in our partnership agreement. In the LLC, your membership interest, your ownership interest, they are not freely transferable. But you may not demand buyout at any time. So in that sense, it is like the corporation and not the partnership. This last one, this may depend on jurisdiction. And once again, for the LLC, we said there's not a tremendous amount of consistency among the 50 different states. So you have to read your LLC statute carefully. But under the Uniform Limited Liability Company Act, a member may not transfer her ownership interest unless all the other members agree to it, and a member may not demand buyout of her ownership interest from the other members or from the LLC at any time. She has no right to demand to be bought out. All right, let's talk about the closely held corporation and the transfer of shares in the closely held corporation. We understand the default rules. The default rules are that my ownership interests are freely transferable. Right? Now, we might want to change that in a buy-sell agreement. We might want to use a buy-sell agreement to address the transfer of interest in the closely held corporation. What is a buy-sell agreement? Simply, a buy-sell agreement is just an agreement where the shareholders agree how they're going to handle the transfer of their shares. It might be a standalone agreement, or it might be part of a larger shareholders agreement. We'll just call it the buy-sell agreement. Why might we want to use a buy-sell agreement? Well, our shares are freely transferable, but I might not want you to transfer your shares to a third party without my consent. We're a closely held business. I'm in this business with you for a reason. You might bring skills to the business, whether they're hard or soft skills, or I might just get along with you and feel that I can do a business with you and that I trust you. And so I don't want you transferring your shares to some third party that I don't know, that doesn't have your skills, or is someone that I might not trust. So it's about continuity of ownership. In this sense, I want to restrict the transfer of shares so that we have a continuity of ownership. There's another issue we might want to deal with in our buy-sell agreement, and that's the issue of liquidity. Remember, imagine that I'm a shareholder and I want to sell my shares. Well, who am I going to sell them to? There's no liquid market for my shares. I can't just go out on the public market and say, I have these shares in a closely held business. Somebody please buy them. No one will buy them. And I might even be violating securities laws by doing that. First, and most importantly, there's just no market for those shares out there. So if I want to exit my investment, there's no way for me to exit my investment. We might want to use a buy-sell agreement to create liquidity for shareholders. We might have a provision or a buy-sell agreement that requires the corporation to buy a shareholder out, or requires the other shareholders to buy a shareholder out. We might want to deal with both of these issues in a buy-sell agreement. So let's look at the typical issues a buy-sell agreement will address. Buy-sell agreement will deal with the death of a shareholder, the disability of a shareholder, the divorce of a shareholder, the bankruptcy of a shareholder, the employment of a shareholder, the exit of a shareholder, and the retirement of a shareholder. In other words, in any of these events, how are we going to deal with the transfer of shares? So let's just deal with the first one so you get an example. If a shareholder dies, what will normally happen to that shareholder's shares? Well, those shareholder shares will go to the shareholder's heirs. And I'm not trying to rhyme here, it just happened to rhyme. So the shareholder shares will go to the heirs. The shareholder shares will maybe go to its children. Well, maybe you don't want to work with that children. Your co-shareholder has passed away. And now the children inherit the shares, and they become the shareholders in the corporation with you. You might not want to work with them. They might not want to be part of this corporation. They might rather have cash. Now, think about you as a shareholder, and you say, what happens to my shares if I pass away? And you might say, well, I want to take care of my family. I want my family to have cash, and I don't want the shares to pass to them. What I would like is I would like the corporation to buy out my shares upon my passing, and then the money will go to my family. So this is one possible solution, and this is how we would use the buy-sell agreement to deal with the issue of a shareholder passing away. What if a shareholder becomes disabled and either needs the money or can no longer perform the function that we're supposed to perform in the corporation? We might want to fashion some sort of buyout for the shareholder in that situation. What if the shareholder becomes divorced, and under the law, the spouse is entitled to half of the shares that our shareholder has? Now you have another shareholder, it's the ex-spouse. That might create problems. You might want to have some sort of buyout provision in the buy-sell agreement that deals with this situation. What if a shareholder becomes bankrupt, and the bankruptcy administrator says, here are the shares, we're going to liquidate these to meet the shareholders' debts? Well, you might want to provide for something like that in the buy-sell agreement. What if we fire one of the shareholders, or what if one of the shareholders quits her job with the corporation? Do we still want her holding shares in the corporation? We might want to fashion some sort of buyout in that situation too. What if a shareholder just wants to exit her investment? She needs money. How can she exit her investment? There is maybe no third party that wants to buy her shares, or if there is a third party, maybe the other shareholders don't want to work with that third party. We have to fashion some sort of provision in the buy-sell agreement to deal with this possible contingency. And then finally, retirement. You can think of retirement as part of the employment issue. What if a shareholder wants to retire? She wants that money. She needs that cash so that she can enjoy her retirement on that island somewhere in the Bahamas, right? How can she get that money? Well, we might have a provision in the buy-sell agreement where we buy her out upon her retirement. I like to call this DDD beer, right? 3 Ds and a beer: death, disability, divorce, bankruptcy, employment, exit, and retirement. This is how I remember it. This is my mnemonic device. I hope it works for you. All right, let's continue talking about our buy-sell agreement. Now, we talked about all of the events that we might want to address in a buy-sell agreement. We might want to have some sort of buyout. Well, how is this buyout going to work? Is it going to be a cross purchase, a corporation purchase, a combination, or a third-party purchase? Anytime we're talking about the transfer of shares, it's going to be one of these, right? It's going to be a cross purchase where the shareholder sells her shares to the other co-shareholders. Our buy-sell agreement might provide for that type of solution. It might be a cross-purchase. Anytime a shareholder is transferring her shares, one of the possibilities is that she's transferring her shares to the corporation. This is what we call a corporation purchase or a redemption, where the corporation purchases the shares from the shareholder. Our buy-sell agreement might have a combination of both. That first, the corporation has an option to buy the shareholder shares, and if the corporation doesn't exercise that option, then the other shareholders get to buy the shareholder shares. Or we might reverse it. That would be a combination. Or we might envision a situation where our shareholder is selling to a third party. All right, as we just said, our buy-sell agreement might have a cross-purchase option where the other shareholders will buy the shareholder's share, or it might have a redemption provision where the corporation purchases the shareholder shares. Or we might be envisioning a situation where a third party is purchasing the shareholder shares. In either case, in any of these cases, our buy-sell agreement should deal with these possibilities. So when we have a cross-purchase or a redemption, a corporation purchase provision, then we have to decide whether we want to make the provision mandatory or optional. So if we have a redemption that is mandatory, then the corporation is required to purchase the shareholder shares. If we have a redemption provision that is optional, the corporation will have the option to purchase the shareholder shares, but will not be required to do this. The same with a cross-purchase. If we have a mandatory cross-purchase, then upon the happening of one of the events, the other shareholders will be required to buy out the shareholder shares. If we have an optional cross-purchase, then the other shareholders will have the option but will not be required to purchase the shareholders' shares. When our shareholder is contemplating or already has an offer from a third party, there are generally two ways of dealing with this in the buy-sell agreement. Either a right of first refusal or a right of first offer. These are very similar, but there are standard ways of referring to them, and you should know them. So first, the right of first refusal. The right of first refusal assumes that we have an offer from a third party. The shareholder has an offer to purchase shares from a third party. If the buy-sell agreement has a right of first refusal, the idea is that before the shareholder can sell the shares to the third party, the shareholder has to give either the corporation or the other shareholders an option to purchase the shares before the third party can purchase those shares. If and only if the corporation or the other shareholders do not exercise the option to purchase, then the shareholder can freely sell her shares to the third party. A right of first offer is very similar, but the difference with the right of first offer is that before the shareholder goes out to seek a third party or to get an offer from a third party, the shareholder must first say to the other shareholders, listen, I want to sell my shares. If you don't buy them, I'm going to go out to a third party. Or maybe the shareholder says this to the corporation. If you do not purchase my shares, I'm going to go out and sell them to a third party. So I'm first giving you, my co-shareholders or the corporation, an option to purchase the shares. If you don't exercise that option, then I'm free to go out and find a third-party purchaser. So this is the right of first refusal and the right of first offer. It's important for you to understand the distinction between these two drafting provisions. All right, let's now talk about what a tag-along right is and what a drag-along right is. So tag-along rights and drag-along rights are in the situation where we have a third-party purchaser. I'm a shareholder and I have found a third party to purchase the shares. Now imagine you're the minority shareholder here. You're the other shareholder and you say, you know what, I'd like to sell my shares out too. Or I don't want to be in the company with a new shareholder. Imagine that the shareholder who's selling out is the controlling shareholder and they're selling the control interest to a third party. The minority shareholders might say, listen, I don't want to deal with another controlling shareholder. We want out too. Well, a tag-along right is where the selling shareholder has to negotiate with the third party purchaser to buy out the minority interest too. In other words, if the shareholder has found a third party purchaser, the other shareholders get to tag along. They get to go along with the sale. So the idea is that I want to sell my interest in the corporation. I found a third-party purchaser, but I've entered into this buy-sell agreement with a tag-along right. That means I can't sell to this third-party purchaser unless the third-party purchaser buys all the shares, my shares and my co-shareholders' shares, because my co-shareholders have a tag-along right in the buy-sell agreement. A drag-along right is just the opposite. Imagine I have found a third-party purchaser and I don't have all of the shares. And the third-party purchaser says, listen, I want to buy your shares, but you have minority shareholders. I don't want to deal with the minority shareholders. The third-party purchaser says, I want to get 100% of the shares. And I say, listen, I don't control everybody's shares, so I can't sell. But if I have a drag-along right in the buy-sell agreement, then I get to force my co-shareholders to sell out with me. So once again, if I found a third-party purchaser who wants to buy my shares, but also wants to buy all of the shares in the corporation, wants to buy my co-shareholder shares, I can't force them to do that unless I have a drag-along right in my buy-sell agreement. All right, continuing on with our discussion of the buy-sell agreement. When we have a cross purchase or a corporation purchase or a tag-along right, a drag-along right, or a right of first refusal or a right of first offer, in any of those situations, we're going to have to draft the price of the purchase. There are three basic options. There's fair market value, there's book value, and there's adjusted book value. Fair market value is what a willing buyer would pay for the shares. Fair market value should reflect the business as a going concern. Remember the valuation lessons we had? How the value of the company is based on the prospective future profits of the company. This is fair market value. We might have book value, which is usually a much lower valuation than fair market value. Book value is just assets minus liabilities. Why is this a lower valuation than the fair market value? Well, it doesn't reflect the going concern value. It doesn't reflect the potential future profits of the company discounted back to present value. That's what fair market value is, right? The potential future profits of the company discounted back to present value. Book value is just assets minus liabilities. It's a very low valuation. Adjusted book value is very close to book value, except that the assets are given their fair market value. Your book value, your assets on your books are not necessarily the fair market value of the assets. Adjusted book value will adjust the value of the assets. What would a willing buyer what would a buyer on the market be willing to pay for these assets, rather than what they're actually listed on in your balance sheet on your books.